Good evening, everyone. My name is Li Wei McBain. It is my honor to be here to be your MC for tonight. And how's everything going, everyone? It was cold here, Texas. We have a snow. This is the first snow in this year. So, so you can type where you are located and just say hi. And so tonight we have very important topic about estate planning, will and trust. Well, I'm very honored to have our very experienced estate planning attorney, Jacob Stewart, to join us. Let me give you some brief introduction about Jacob. Can you see my screen?
Yes.
So Jacob is a managing attorney and a partner for Intervivo, the largest estate planning firm in the world. He oversees and he directs the firm's operations and attorneys in the southwestern United States, including Texas. Before joining Intervivo, Jacob was the chief tax and asset protection consultant for a large asset protection company. Jacob has helped thousands of medical professionals and other small business owners across the country reduce their tax burden, protect their assets, and plan for future generations. Jacob has also advised thousands of CPAs, attorneys, and financial advisors all over the country and continues to provide tax and estate planning services to individuals and financial professionals nationwide. He speaks fluent Spanish and French as well. Jacob, his wife, and their six children live in southern Utah near Zion National Park. I'm so glad Jacob can spend some time with us and share with us his insight into estate planning. Okay, next, I'm going to give the stage to Jacob. Jacob, are you ready? The stage is yours. Okay, great.
All right, I'll take over the screen if that's all right. Let's see, is my screen, I think the wrong screen is showing. Let's see. Okay, can you see my screen?
Yes, very clear.
Okay, very good. All right, well, thank you everybody for joining us. I'm privileged to be able to be with Li Wei and her co-workers and all of you guests who've come. So I want to speak on estate planning today. And as we go through this time together, if you have questions along the way, go ahead and enter those in the chat box. And at the end, or maybe even throughout, I'll answer those questions to the best, as far as we have time to do so. So I appreciate the introduction, Li Wei. As she said, I'm an estate planning attorney with our law firm's called Intervivos. You'll see here the LSPN. LSPN is the professional network of attorneys that services, in particular, the World Financial Group and Transamerica Advisors. And so that's our white label, I guess, that we use when we work with these advisors. And so that's what that's about. So estate planning. Estate planning is a topic that a lot of people don't understand very well. So I hope that in our time together, you'll come away from this with a better understanding of what estate planning is and the importance for each individual to take care of their planning. Statistically, less than half of the people in the United States have any sort of estate plan at all. And even those about 50% who do have some sort of estate plan, it's generally not a very good estate plan. It's a plan that somebody got offline, or they worked with an attorney who wasn't a specialist, right? They did their planning with just a general practitioner attorney who essentially just filled in some basic forms for them. And so as I review people's planning or talk to them about their planning, even those who've done it, usually it's outdated or it isn't done very well in the first place. So what is estate planning? Estate planning has three main components to it. The first is what we call a life plan. meaning the parts of the planning that affect you while you're still alive. A lot of times when people say estate planning, they think, well, what happens to my stuff when I die? But there's also an aspect of estate planning that affects you while you're alive. Specifically, what happens if you become incapacitated, right? Who makes decisions for you? Also, how do you protect your assets so that you have money in retirement that you can use for your living expenses? And third, how are you going to take care of long-term care costs? All of those are elements of an estate plan for while you're still alive. So each of these in turn, incapacity, first of all, if you're not able to make decisions for yourself, who can make those decisions for you? Well, if you don't have any documents in place that state who can make those for you, then the default is to go through what's called a guardianship or a conservatorship proceeding in court, which takes time, costs money, and you may end up with results that you didn't want. And when I say money, usually in the thousands of dollars range, right? For the court, a judge to determine who can make decisions for you. There's kind of two categories of decisions. There's financial decisions, managing your assets, your stuff. And then there's medical decisions, which is, who decides what type of treatment you should get, what doctors you see, what facilities you go to, that kind of thing. So if you don't have any documents, then a court decides who's going to have those powers for you. Ideally, you would want to have what's called a financial power of attorney and a medical power of attorney. Each state calls them something a little bit different, but essentially one document is for making financial decisions for you, and the other is for making medical decisions for you. Anyone who's age 18 and over should at the very least have financial and medical powers of attorney in place. There's no reason not to. Those are documents that can be found fairly easily online. They're pretty standardized. Each state typically will have its statutory form that it prefers you to use. So now you may or may not understand how to fill it out correctly, but the form itself and doing it is fairly simple. So everyone 18 and older should at the very least have that. The second category, like I said, is asset protection. Now, that's a broad topic. I'm not going to spend a lot of time on it, but basically making sure that your stuff is protected in case of a lawsuit or maybe a separation of marriage or something like that, a divorce. And a lot of people think that a trust will do that, but generally a trust isn't an asset protection tool. Generally, you're using the state laws, first of all, because each state protects different things. For example, Texas protects your home, so nobody can take your home. Texas, except the lender, of course. So nobody can take your home. Nobody can take your IRAs, your 401ks, your life insurance and annuities are protected in Texas. Other states like California don't protect any of those things, or at least protect very little. So each state's going to be a little different as far as what it protects by default. So then you go from there, you go to, okay, what assets need protecting and how do I protect them? And again, the strategy is going to be a little different depending on the state. But generally, rental properties, for example, rental properties aren't protected in any state. So you would want to have appropriate insurance for those, but you'd also probably want to own your rental properties in an LLC, a limited liability company, which gives those legal protection in case of lawsuits, as long as they're structured correctly. So, and each property is usually going to be in its own separate LLC. So you want to separate at-risk assets from one another. That's just kind of a quick overview of what asset protection is aimed at accomplishing. And then the third category is long-term care. So there, the concern is running out of money and not being able to pay for your long-term care needs. If you are ever need to go into a rest home or an assisted living, or have somebody come to your home to take care of you, that gets very expensive. And so the best way to address that is through long-term care insurance or a long-term care rider on a life insurance policy. But in some cases, if you haven't been able to do that, then you want to try and qualify for Medicaid. And so there are legal tools that that you can use to qualify for Medicaid, different types of trusts and different ways to convey property to other people. The rules for that are very complicated. And so you want to work with a professional to be able to qualify for Medicaid and or to exempt assets from Medicaid recovery when you pass away. So that's long-term care. All of those are part of the life plan. The second type of plan that also is incorporated into estate planning is what we call the transfer plan, right? Now, this is the traditional, who gets my stuff when I die? So for this, I think I've got, well, I didn't mention. So on this slide, these are 4 or 5 important documents for any estate plan, right? So I mentioned already durable financial power of attorney, medical power of attorney. A living will or a medical directive is a statement or a document that says what happens at the at end of life type situations, like I want to be taken off of life support, or I want to be kept on life support no matter what, or I require 2 opinions, 2 doctors to weigh in, and I want a waiting period and that kind of thing before I'm taken off of life support. So that's what that document is. These next 2 documents, a last will and testament and a revocable living trust, those are the documents that are specifically used to transfer your assets at death. And I want to talk focus most of my time on these documents and on this part of estate planning. So there are really 3 options to take care of this part of your estate planning. The first option is to not have a plan, right? To not have any documents in place, which is what more than half of the people in the US have by default chosen. Each state has probate laws. Those are laws that determine who gets what when you pass away. So those probate laws generally say, okay, everything goes to the spouse and then the kids and then, you know, other family members, depending on who's alive at that point. Each state is a little bit different, so it varies, but that's the general idea. Now, the problem is most people are not in the cookie cutter situation. One perfect example of that is, let's say you have somebody who is in a second marriage or who has a blended family. I had a client in Texas who was trying to do her estate planning. Her husband had recently passed away, and he didn't have a will, he didn't have a trust, and they owned a house together. So in states like Texas and California, those are community property states. So whether the person's name is on the title or not, half of the asset belongs to your spouse normally, right? So in this case, both spouses' names were on the title, but it didn't have to be that way. So what happened was the husband and wife had been married for about 20 years. They bought this house together and lived in it together for a long time. But prior to their marriage, the husband had had a daughter, and the daughter had become estranged, meaning her and her father and her stepmother hadn't had any contact for many, many years. Well, the default probate law in Texas says that in a family where the child is not the child of both the husband and wife, 50% of the deceased spouse's estate goes to the child or the children. And so in this case, that means that a portion of the house by default was supposed to go to this daughter instead of to the wife. Well, this is problematic for a few reasons. Number one, now the wife loses a portion of the house. She doesn't own it anymore. That would be okay. That was okay with her, actually. But to make matters more complicated, she isn't able to refinance the house. She isn't able to sell the house or do anything with it without the approval of this estranged stepdaughter. But they can't even locate the daughter so that they can go through probate and put 25% of the property in her name. So now the wife is kind of stuck where she is. And she can't do her own estate planning completely either. In other words, she can't move the trust, or excuse, she can't move the property to her trust because 25% of that property belongs to this stepdaughter. So you can see where this would, you end up with results that you didn't want. If the husband had had a will or a trust, that would not have been the case. He could have left everything to his wife. So that's just one example of how not having the right documents in place can be very problematic. Now, I've mentioned a few times this term probate. Probate is not necessarily a bad process, right? It's good that we have probate, but it's not a process that you want to get into if you don't have to. And what I mean by that is it's a court process. And as anybody who's ever been to court knows, a court process takes time and it costs money. So probate is no exception, right? I think Li Wei mentioned right before this started that she had a friend that is currently in probate and has been there for over a year already. That's not uncommon. Probate generally takes anywhere from several months to several years. I met somebody the other day, or a few years back, they'd been in probate for 8 years. And then another one in the same office said, well, I've been in it for 10 years, right? So probate can drag on a very long time, especially if there's any kind of conflict or my mind just went blank. Conflict or complex circumstance, right? So probate, if we can avoid it, that's better, right? So how do you avoid probate? Well, before I get there, I want to talk about option 2. Option 2 is to have a last will and testament, or a will, right? Now, a will doesn't avoid probate, but it does allow you to deviate from the default laws of the state. So in this case, I mentioned, if the husband had had a will, the wife would have still had to go through probate, but he could have had everything go to his wife. So it could have been resolved fairly easily. Yeah, it would have taken 6, 10 months, a year, whatever. But at the end of the day, she would have owned the house free and clear. Now, it would have cost for her, if the daughter didn't try and contest it, if it wasn't too complicated, probably would have cost a couple $1,000s to go through probate for her husband, right? Maybe more, maybe less. So that's if he had a will, right? Or even if he didn't have a will, that process would have taken place. So a will is all right. It's better than nothing. It's simple for the most part, but your stuff still has to go through probate. So option 3 is to have what's called a trust, a revocable living trust or a family trust, are different terms for the same thing. But a trust is a legal entity. It's a tool that allows you to put your property, into that legal entity, that trust. And when I say your property, I mean your real estate, your home, rental properties, business entities, bank accounts, vehicles. Your trust can even be the beneficiary of life insurance policies, IRAs, 401ks, all of that, right? And that's the goal. That's the ideal, is to title everything in the trust. Now, people ask, well, I don't want to give up control of my assets. I don't want to put them in its other entity. It's important to understand that putting stuff in a revocable trust is almost the same as owning them in your own name as far as your control and access goes. Meaning you, the person who created the trust, you have complete control over your assets in the trust. You can buy stuff, you can sell stuff, just as if you owned it in your own name. The only difference is you sign as the trustee instead of as you personally. So it doesn't change your taxes. It doesn't change your access or your control. It's a very simple tool to use. Its goal, the purpose is to avoid the probate process. So the reason why that works is that anything owned by the trust, when you die, the trust is a separate legal entity. So it continues to exist it continues to hold title to your assets. What changes is the trustee. So when you create your trust, you assign what are called successor trustees. In other words, people who take over the management of the trust for you if you become incapacitated or when you pass away. So those successor trustees at that point then carry out the provisions of the trust. They carry out your wishes and they distribute things to the people that you've listed. And you can pick whoever you want as the trustee. It can be your kids, it can be your other family members, it could be a bank or a corporate trustee. You get to choose. But the choice of the trustee is very important. And it's also important to think through different scenarios and protections that you want to put in place, because the trustee has a lot of authority and power. So you want to make sure that there are checks and balances on the trustee's power. Those are all things that you talk through when you set up a trust with an attorney. Okay, so a trust has the grantor, that's you, that you're the one creating the trust. It has the trustee, which is also you when you're alive, and then you pick successor trustees when you pass away. And then a trust has beneficiaries. Those are the people who benefit from the trust, which again is you while you're alive. And then when you pass away, it's, whoever you list, probably your kids, could be grandkids, it could be your dog, it could be a charity, whoever you want to list as your beneficiaries, right? So in a nutshell, that's a revocable trust. Revocable means that you can change the trust, meaning you can amend it. You can change the provisions anytime while you're alive. So as laws change, as your circumstances change, you can amend the trust. You don't have to make changes to the trust if you buy a new house or if you open a new bank account or open a business. The trust itself doesn't have to change necessarily in those situations. It's an empty shell. You can title stuff in it, you can take stuff out of it without changing the trust provisions itself. But that being said, maybe you want to change the trust provisions. The point is you can do that anytime during your life. Now, there are different types of trusts called irrevocable trusts, meaning they cannot be changed. When you die, your trust becomes irrevocable, but you can create an irrevocable trust while you're alive as well for specific purposes. So normally they're for tax planning, estate tax planning, and I'll get to that in a minute. But there are irrevocable trusts for specific purposes, which I'll go through in a little bit. So in a nutshell, those are the different documents and the options for your for your transfer plan. You can not have a plan and stick with the default laws of the state. You can have a will, or you can have a trust. Now, the next question becomes, when should I create a trust as opposed to just having a will? And the answer is when you need to avoid probate, or when you want to put special protections in, that's when you have a trust. So more specifically, when you own real estate, like a home, for example, or if you own a business, or if you have young children, or if you have a special needs child, those are the most common reasons for having a trust as opposed to just a will. So if you own a home or a business, or you have a special needs child, or if you have young children and you want more specific controls and provisions, that's when a trust might be the best solution for you. So most people, right? Most people fall into those categories. So you'll see here on this slide, right? Everything going into the trust, right? The life insurance, the savings, the bank accounts, retirement accounts. Usually you list the trust as the beneficiary on those. The trust doesn't own them directly, but it's the beneficiary. So then the question is, well, why would I need to name the trust as a beneficiary? I'll give you a perfect example. I had a client the client's spouse had passed away, right? The client's spouse passed away and had named children as the beneficiaries on the life insurance. Well, the children were under 18. Even though the surviving parent was there, the life insurance company wouldn't release the money to the guardian. without going through a court process and all this complication. So the life insurance money was locked. They didn't even have access to it, which was a problem. So in that case, if the deceased spouse had listed their trust as the beneficiary instead of the children, then not only would the trustee, the surviving spouse, have gotten direct and immediate access to that life insurance money, but also the trust protections could have applied to that life insurance money. And what I mean by protections is you can put in provisions in case of the remarriage of the surviving spouse. You can put in provisions, more specific protections and provisions about when and how the children can access the money. Instead of just getting it at age 18 and doing whatever they want with it, you can say, all right, well, at age 25, they can get 25. And then at age 30, they can get another, half of what's left. And then, at age 35, they can get the rest. Or you can say, I want it to stay in trust perpetually, and they can access it just for their medical, education, housing, food. And, maybe they can take out up to 5% per year over time, right? So you can plan for multiple, future generations. There's a lot you can do with a trust. So you almost always want to name a trust as the beneficiary of life insurance, especially if you have a big death benefit. But you'll see here real estate, like a home, rental properties, personal residence, personal items like your furniture, jewelry, you can, all that would go into the trust, business interests and other investments as well. So all of that would typically go into a revocable trust. But I mentioned an irrevocable trust and some circumstances where that might apply. Again, revocable means you can change it. Irrevocable means you can't change it once you set it up. So there are several instances where an irrevocable trust might apply. Number one, certain Medicaid planning, right? I mentioned Medicaid earlier. Medicaid planning often will use an irrevocable trust. Special needs planning. So if you have a special needs child, sometimes you would set up an irrevocable special needs trust. Or depending on the situation, you'd have special needs provisions in your revocable trust. Just depends on the circumstances. For estate tax planning, there are lots of circumstances where you might use an irrevocable trust. Now, most people don't have to worry about estate taxes because the exemption for US citizens and residents is $12 million per person. So if your estate is worth less than $12 million, at least under current law, you don't have to worry about estate taxes. But it does apply for people who have a larger estate, or it applies for people who live in a different country, but who own assets in the US. I'm actually in the middle of helping somebody. They live in Israel and they have a lot of assets. They want to invest in real estate in the US. It's very tricky, complicated to do this, and not be subject to gift tax and also not be subject to estate taxes when that person dies. But you can use a special type of irrevocable trust and they can gift money to that irrevocable trust. And then that trust can invest in different assets and real estate and that kind of thing. And as long as it's designed correctly, they can be exempt from estate taxes and from gift taxes. So that's a circumstance that I'm working on currently where it's an international person that's wanting to own property in the US. There are other circumstances where, for example, life insurance. If you have a lot of life insurance or if you have a large estate, you can move your life insurance out of your estate or purchase life insurance outside of your estate through what's called an irrevocable life insurance trust. They're specialty trusts that are designed to hold life insurance. And depending on the type of life insurance, the trust is designed in different ways. Like if it has cash value, for example, or if it's a second to die policy, there are lots of different types of insurance. And so the trust, a person may need 1 or 2 or 3 different irrevocable life insurance trusts to meet their different circumstances. Another example is when you're doing special charitable or tax planning. there are different types of irrevocable trusts that you would use for tax planning in the sale of a property or a business or stocks or cryptocurrency. I've actually had that come up a lot recently, where people are making tons of money on their cryptocurrencies and wanting to mitigate or avoid or reduce their taxes. So there's different types of irrevocable trusts that can be used for that type of planning as well. So so I've touched on a lot of things there. I'm just trying to give you an overall idea of when trusts can be used. But the most common use, like I said, is just regular estate planning in a revocable trust. Now, a revocable trust, before I move to my next slide, revocable trusts come in different shapes and forms. The difference in them is in the details and the provisions that you have. So I mentioned earlier that a lot of people who do planning, their planning isn't very good. And sometimes those people will set up a trust, right? But maybe their trust, they set up their trust online and used like LegalZoom or Rocket Lawyer or one of these things. I've never seen one of those trusts done correctly. It's not to say that the trust itself is necessarily bad, but people don't understand trust well enough to fill out the forms correctly. I've never seen one done right. So that's generally not a good idea, right? I've seen a lot of plans also done by attorneys that aren't experts in estate planning. And essentially the attorney is just using an out-of-the-box form, filling it in, but a lot of the protections and details that I like to see aren't in there. So will it avoid probate? Probably. Will it address a lot of other what if scenarios and protections? No. So the best case scenario is to work with an experienced estate planning attorney. Does it cost more? Yes. But you're going to land up with a better result in most cases, as long as it's a good estate planning attorney. Now, that being said, some situations are simple enough where an online tool might be okay. We have a solution that is kind of a hybrid between using an attorney to guide you through kind of an online tool and a fully custom plan. So for people with really simple needs, we have a lower cost plan that we call our assisted plan, where we're using kind of forms, but they're really they're high quality forms. And a paralegal is going through the process and helping the person fill it out, and then an attorney is reviewing it. Okay, so that's more of a simple, less expensive plan, and that's going to range around $1,000. And then we have more of a custom plan where you're working with an attorney, and you have a lot more flexibility in the types of provisions that you put in and the protections that you include. So if, for example, if somebody owns a business or has international assets or has a blended family or owns a lot of, has a larger estate, or they just want more custom provisions, then that's when a custom plan is going to be more appropriate. Costs for custom plans usually range from $2,000 to $4,000 on the more standard, for most people. And then, of course, it can go way up from there if you have a really high net worth or complex situation. I've seen plans for over $100,000, but that's rare. So most plans are usually between $2,000 and $4,000 for custom on the custom side. So just to give you an idea of a ballpark on costs, all of which are cheaper than going through probate, usually, right? So one other comment I'll make on the trust planning. One thing that I've seen over and over again that people don't do properly is a trust is only as good as what you put in it. Meaning, if you don't transfer your real estate, or if you don't transfer your bank accounts, or if you don't transfer your vehicles to the trust, then those items will still have to go through probate. And what I see is a lot of times people will transfer some things to the trust, but they leave out other things. I had a client, I did their plan for them. I helped them transfer their home to the trust and helped them with some other things. And then I gave them instructions specifically to move their bank accounts to the trust and told them, I'm there to talk to your banker if you need me to. but I can't go to your bank and transfer the bank account for you. You have to do that. So I left very specific instructions for that. Well, the client didn't follow my advice and she passed away. And so those bank accounts, luckily it didn't have to go through a full probate process, but it was a longer, more complicated process, and it's still kind of dragging out. So when you have a trust, it's important to follow through and put the assets in the trust. The attorney normally helps with as much of, or should help with as much of that as possible. But there are some things you're going to have to do yourself, like transfer the bank accounts. An attorney can't do that for you. So it's called funding the trust. It's important to change title of everything to the trust and be thorough with that. All right. Now, it's still better to have a trust. Even if you don't fund it, it's still better to have a trust than a will, because even if the assets have to go through a probate process, it's a simpler process than if you didn't have a trust. And at the end of the day, the assets will be controlled by the protections and provisions of the trust. So it's still good to have a trust, even if you haven't fully funded it. But the best situation is to put everything in the trust. So that's the last comment I'll have on that. A few things I'll just mention here, and then it looks like I have quite a few questions to get to. The third aspect of estate planning is what I call the family plan. So these are the non-asset aspects of a plan. And what I mean by that is, for example, who's going to take care of your kids if you pass away? So if you have children under 18, I think the most important part of your plan is who's going to take care of your children. So there's a document in some states called a declaration of guardianship. That's super important. In other states, it's part of the will. You name your guardians in your will, right? So guardianship for the children is super important. There were some individuals in Utah, where I live. They had 3 children. They didn't have a will or trust or anything, and they went hiking. They went off for the weekend in the mountains. Which, if you've never been to southern Utah, I highly recommend visiting our national parks down here. We have Zion National Park. We have not too far away Arches. We have several national parks pretty close to southern Utah. Anyway, so they went and went up into the mountains, and there was a storm, and that doesn't happen very often here, but it did while they were camping. And so they got underneath a tree to get out of the storm, and the tree was struck by lightning, and it killed both parents. And so now we have the kids who are orphans, and in their case, both sets of grandparents wanted custody of the children, as any good grandparent would want, right? Well, both sets of grandparents had to go through this court process, and both got an attorney, and they were arguing who was more suitable to be the guardian of the kids. Well, that dragged out it took 5 years for the court to come up with a final determination. Can you imagine the emotional turmoil for the kids? They've got their family fighting. They're going between temporary guardians in the meantime. But not only that, but it was costing probably tens of thousands of dollars for the grandparents. And they didn't even have access to the life insurance money or the IRAs or the 401ks because a guardian was not determined. So a horrible situation that could have been avoided with a very simple document. So that's number one priority whenever there are children under 18. But there's other things too. For example, tangible personal property, right? The avoiding conflict, communicating, right? We want to make sure that we not just do our plan, but that we've communicated that, and people know where to find the plan. I had a client years ago. They did all their planning, and then they didn't tell their kids where they put their documents. The mom died, and the kids didn't know where to find the documents. They came to our company and said, "Hey, we found your information in our mom's stuff. Do you know anything about this?" "Yeah, we do. We helped them create some estate planning documents." "Great. Can you send those to us?" And so we said, "Yeah," but she never sent us her signed documents. All we have are the unsigned versions which are not legally valid. So it didn't do any good. In other words, the mom did her planning, but her kids still had to go through probate because they didn't know where to find these documents. And so the mom's wishes weren't carried out at the end of the day, and the kids still had to go through probate. So communication is another really important factor to be aware of. Last thing I'll mention here, well, two more things. Number one, digital assets. So how many of you have computers, cell phones, online accounts that have pictures and videos and movies and all this stuff? Some of the most important things that you own, but if you die, your family members can't get access. Apple is the worst. iPads, iPhones, you can't get into those for anything, right? And if you try, then it's locked up forever and nobody can get into it. So having passwords written out for your online accounts and your devices is important. It's not part of your estate planning documents, but it's something that you should do as part of a general estate plan. And then the last thing I'll mention is that's valuable is memories, family stories. You know, record family stories, journals, emails, videos, whatever, and make sure that your family members can get access to those. I had a family reunion a few years back with my grandparents. They turned 90 about 4 years ago, and so we all got together. And my brother-in-law does videography, and he was videoing all this. And he made DVDs, copies of that for everybody. And it is something, my kids have watched it dozens and dozens of times, and they remember that reunion better than any other family event that we've had. And it's captured forever, right? Their kids, my grandkids, will be able to see that family reunion and hear the story of when their grandpa met Amelia Earhart, or great grandpa. My grandpa knew Amelia Earhart, which is pretty cool. I hadn't heard that story before, but now we have it on DVD. So those are some of the intangible things that are part of a good estate plan that, you know, an attorney can bring up or walk you through, but at the end of the day, it's just something to be aware of. Okay, I've talked your ear off. I will now jump into these questions. Hopefully I can get to all of them. There's lots of them. So let's see.
Yeah, thank you, Jacob. I can repeat. So thank you for your wonderful explanation. And I really think we need to start to consider what we need to plan to protect our loved ones. It's not about you, because I'm alive, but when I pass away, I don't know anything, but it's about the people we care for. And so the first question is that so someone's talk about whether you can, let me see, there's several. If you have any question, you can also unmute yourself to ask Jacob directly.
I'll start with the ones that have been texted or, you know, chatted in.
Okay.
I want to make sure we get to those. So it's the first one I see is, for blended families with children, is a revocable living trust the best way to go? Yes. Anytime there's a blended family, the main concern is if you have a will, usually what happens is you leave everything to your spouse, and then the spouse has to, you know, you leave it up to the spouse whether they're going to give stuff to your kids or not, right? So there's no protections in place necessarily. You can work some provisions into a will that addresses that, but it's not ideal. Most people want everything to go to their surviving spouse so that the surviving spouse has stuff to use. And then whatever's left, they want their share to go to their kids and the other share to go to their spouse's kids, that kind of thing. So yes, a trust allows you to put those types of provisions and protections in place. Even if you don't own a home, maybe you have life insurance money, or you have other investments, bank accounts, whatever. And so a trust allows you to put those types of protections in place for your kids and for your spouse's kids and for your surviving spouse. That's a good question. Next question. My friend's mom passed away suddenly and she didn't have a trust or a will. How would he change property to his name? So the first step there would be going through probate. So you start a probate proceeding in the appropriate jurisdiction, which is usually where the person passed away. And then the laws of that state will dictate who gets what. Well, they dictate what percentages go to people. It doesn't specify which assets go to specific people. So that in and of itself can be a conflict. But that's the first step is you start a probate proceeding. And usually you want to use an attorney to do that because it's complicated. And then it says he also lives with her, but the deed is all in her name. That's going to depend. If it was community property, regardless of whether the deed was in her name or not, it still has to go through probate. Now she can continue to live in the house, or he can continue to live in the house, but when it comes to refinancing or selling the property, they're pretty stuck. Plus, when the second spouse dies, now there's a whole additional level of complexity that the kids would have to deal with. So it says there's no lien on the property. He only has to pay taxes and utilities. So yeah, he should be fine as far as being able to live in the house. But if he ever wants to do anything with it, he's going to run into title problems. Oh yeah. So the question was, can he do an affidavit of heirship, or actually what's called what the document is called a muniment of title, and either of those can work if that's the only asset. So that's in Texas specifically, right? It is a probate process, but it's a simplified probate process called an affidavit of heirship or a muniment of title, depending on the situation. So yes, some states like Texas have a simpler process if there's just one asset or if there's a very small estate. But even that is going to cost between $1,000 and $2,000. So again, it's better to have planned and not have to go through that. But after the fact, yes, that's the proceeding that you would probably do. Good question. All right, the second question, the most common estate planning documents you will need are durable financial power of attorney, a living will, medical power of attorney, last will and testament, and a revocable living trust. That's correct. So yes, thank you for restating that. The next question is that why former lawyer who did my last will and testament suggests reaching out to another attorney that has sole focus on estate planning upon my request to revise it? Yeah, probably. So most attorneys, no matter what their practice area, they'll do like a simple will for people. But that's the extent of their experience. Trust planning is a lot more complicated. So attorneys will do those, even general practice attorneys will do them, but they're junk. I shouldn't say that. They're generally just forms that they fill in blanks. And so they're not, unless they're an experienced attorney, there's a lot that they're not going to be aware of as far as what options are available, what protections should be in place. So it's important to work with an experienced estate planner as opposed to just a regular attorney that focuses in a different area of planning. Next question, when POD, pay on death, is set up for financial and transfer on death is set up for the house, can both be relieved from probate? Maybe. So that's a great thing to bring up. I mentioned the three options, no documents or a will or a trust. Technically, there's a fourth option, which is for every individual asset to have a beneficiary designation or a transfer on death designation or a payable on death designation. Not every state allows that. Texas does for property. The problem, though, is if the person you name dies before you or at the same time as you, now you're in a really difficult situation where you're still stuck with probate and it's unclear who's going to be the beneficiary. So that could almost make things worse. Also, a lot of the protections that you might want to have in place aren't going to be included. So for example, if your beneficiary is going through a divorce or is in a lawsuit or has special needs, like for example, they're on Medicaid at that time, or if they're incapacitated, or if, like I said, if they die and now it's their kids, or any number of situations that could apply, the transfer on death deed or the transfer on death designation isn't going to account for that. It's also not going to take care of you during your incapacity. So a trust has protections and provisions that apply not just after death, but also if you're incapacitated. And then from there, the trust can contain provisions. For example, a lot of people don't want their assets to go directly to their kids. They prefer that for their assets to stay in trust with more limited access over time. Or let's say the beneficiary is at the time they're using drugs, or they have a gambling addiction, or they're in jail, or they're out of the country. In fact, some beneficiaries, if you have a beneficiary that's living in a different country, that's a whole different set of complications that need to be addressed. It can be done, but you have to be aware of the nuances, right? So can you avoid probate with those things? Yes. Is it ideal? No. A trust is going to give you more options, more protections, more benefits. Okay. So that's the answer there. Next question. If I have a revocable trust, I better transfer all my bank and brokerage accounts, vehicle titles to your trust. Yes. If you have a trust, transfer everything to the trust. Everything should be owned by the trust. Now, IRAs and 401ks can't be transferred to the trust directly, but you can list your trust as the beneficiary. So that's something you need to do. Yes. Okay, next question. Regarding asset protection, do you recommend a family limited partnership? Maybe. So there are different types of business entities. There are corporations, there are LLCs, there are limited partnerships. Each one has pros and cons. And so the tool that you use is just going to depend on the specifics of the situation. But yes, in some circumstances, a family limited partnership would be better or more flexible than an LLC. But for most people, an LLC is going to be the best option for asset protection. Again, that's an entirely additional topic that I could spend probably 30 minutes or more getting into detail on, but we don't have time for that today. So yeah, that is another option. For those with kids under 18 and both parents accidentally pass away, what's the best way to go about with estate planning? I'll just use myself as an example. So I have 6 kids, all of them are under 18. Several years ago, I set up a trust. Before I owned a house, before I had any assets, I set up a trust. And I had a life insurance policy. Both my wife and I got life insurance policies, and we named our trust as the beneficiary. So the way we set ours up is if we die before our kids are over 18, the trust receives, the life insurance money plus our other assets, and our trustee will manage those assets on behalf of our children. Once our children reach a certain age, they can be their own trustee. They can manage it themselves. And in my trust, I put limitations on when they can access, on how and when they can access that money. So for example, I've put in a provision that says that they can take it out for health, education, housing, and food, that kind of thing, whatever they need, plus, or I should say, or up to 5% per year. So in other words, if they have a job, if they don't need the money for their health and education or all that, then they can still take out up to 5% and do whatever they want with it. But it stays in trust long term, and they can invest it inside the trust long term so that they don't just blow it all, so that it's asset protected. Now, when you're alive, when the trust is revocable, there's no asset protection. But after you die and it becomes irrevocable, it's protected from creditors and from divorce and all that kind of stuff. So that's how I designed my own situation. And most people tend to prefer doing it that way. Next question, does a will need to be notarized? It depends on the state. Most states do not require a notary, but they do require 2 witnesses. In Texas, well, in most states, it's best to have the trust witnessed and notarized, what's called a self-proving trust, or a will, excuse me, self-proving will, so that the witnesses don't have to show up in court for probate. But the only legal requirement, and this applies to all states that I'm aware of, is 2 witnesses. But it's a good idea to have it notarized as well. Next question, what are income-only trusts? So trust, there are only really 2 types of trusts. There are revocable trusts and irrevocable trusts. From there, what differentiates them beyond that is the provisions that you put in it. So what you would call an income-only trust is just saying that the principal can never be touched, but whatever income is produced by the assets of the trust is what's distributed. So income only means only the income is distributed to the beneficiaries. So it's just a special provision that you would put in to preserve the trust for multiple generations. Sometimes we could call that a dynasty trust, because it's something that lasts for, multiple generations as opposed to just 1 or 2 generations. All right, so we're almost out of time. I can probably answer 1 or 2 more questions, but before I do that, one more comment is, all of this information is great, right? Several people have said thank you for the information, but I've done tons of these webinars, and you go home and you forget about it and you don't do anything, right? My plea to you is, knowledge is power if you use it. If you don't use it, knowledge is just knowledge, right? Knowledge is power if you use it. So I recommend that you get started and do some sort of planning, even if you use an online tool as a first step. Great, better than nothing. But reach out to a qualified estate planning attorney. If you don't know a good estate planning attorney, then reach out to the advisor that invited you, and we do a free consultation, right? So we'll do a free consultation, either me or one of the other attorneys in our firm. We're a nationwide law firm, so we can do estate planning anywhere in the country. We do international planning as well. So reach out to your advisor. Contact information to the main office of the law firm is on this slide as well. And just get started, do a consultation and actually do something with this information, and encourage other people to do it too. COVID has been kind of a wake-up call for people. Life is fragile. We don't know when we're going to die. And so better to be planned and prepared than to not have the plan in place. So one more question from whoever wants, and I think that's all we have time for.
So I have another question. A lot of people, especially Asians, we like do everything DIY. And so will and trust, what do you people are just right now just think, oh, have will is enough. So in which income, what kind of income you think people should have, or asset, how much they should have?
Yeah, it's not income or asset specific. It's situation specific. Like I mentioned, a will, anybody can do just a will. That's better than not doing anything, right? It's cheaper, but at the end of the day, it's more expensive. In other words, probate is way more expensive than just doing a trust. And especially all of the protections that you don't have in place aren't going to apply, plus the headache for your family members. So at the very least, yeah, do a will, please. Even if it's an online cheap, do it yourself, whatever. That's better than not having anything, right? But you're going to save a lot of time and money and headache if you work with an experienced attorney and do a trust plan. But the triggers especially are if you own a home or any other real estate, if you have a blended family, if you own a business, right? Even if the home doesn't have much equity in it, just avoiding the probate process is worth doing a trust, right? Or if you own a business, even if it's a small business, businesses lose value very quickly if they get tied up in a court process. If you have a blended family, even if you have very few assets, I gave my own situation. Even before I had assets, I had my children, I set up a trust just for the life insurance money, right? Because the trust gives me far more flexibility and control over that money. So any of those circumstances, a trust would be a much better tool than just a will, but at least do a will and powers of attorney, right? Do something, and then later upgrade if you need to. Does that answer your question?
Yeah, thank you, Jacob. And hey, when you're really very honest. I really appreciate that. So, hey, can you give me 3 tips on how to find a trustworthy attorney, estate planning attorney? What's your
Yeah,
suggestion?
great question. Great question. So number one, the attorney should specialize in estate planning. In other words, at least 50% or more of their practice should be estate planning, at least. Number two, they need to understand your situation. In other words, if you have international assets or circumstances, the attorney needs to understand international planning. If you are a business owner, they need to understand business succession planning and taxes and those implications, right? So it's not enough to just be an estate planning attorney. They need to understand your specific situation. And you can interview attorneys, right? What are their fees going to look like? You know, have them give you an average. If an attorney charges less than $2,000 for a trust plan, they're probably not a very good estate planning attorney. If they charge, you know, more than 4,000, they're probably a good estate planning attorney, but you may be overpaying because they can, right? So so you want to look at cost, and then also you want to look at convenience, right? Some estate planning attorneys are local, and that's great if they're experts. A good resource in general, if the attorney uses what's called wealth counsel as their drafting tool, wealth counsel attorneys, that generally those are going to be pretty good attorneys. That's the software that we use, at least currently, and we have for many years as our base software. But not all attorneys that use that are good, but that's generally they're going to be better than others. So those are just some things to look for. I mean, like I said, our firm is a resource that you can use, but I would say those are the major things to look for. How much estate planning do they do? How many years of experience do they have? What are their general average costs? And what type of drafting software do they usually use? And that'll at least get you a good start looking for an attorney.
Okay, thank you, Jacob. And thank you so much for helping us to understand how to prepare well for our loved ones. So if you have any question, please reach out to the person who invited you to this seminar, and you will get a free will template. But as Jacob mentioned, will is not enough. You have to talk with the professional to get more help. Okay, so that's all for today. Thank you for attending our seminar. I will see you next time.
Thank you, Li Wei.
Okay, live well and leave well. Okay, so thank you. Bye.
Bye-bye.
Have a good weekend.